case number 101724, State of Kansas v. Kleypas. I will now ask counsel to stand and state their appearances for the record.
Good morning. May it please the court. Sarah Ellen Johnson, Capital Appellate Defender Office, and Meryl Carver-Allman, Capital Appellate Defender on behalf of the defendant Gary Kleypas for President Rank Arkansas.
May it please the court, the state appeared by Chris Elslager, Deputy Solicitor General, and Helen Chalmers, Assistant Solicitor General, ready for argument.
Very well, thank you. Counsel, you may proceed with argument.
Good morning. May it please the court. Meryl Carver-Allman, Capital Appellate Defender on behalf of Mr. Kleypas, and Chief Justice Nuss, if I may have 15 minutes for rebuttal, please.
15 minutes is granted.
You were standing in a courtroom, sort of like the one we're in today probably, when someone jumped over the bar, tackled my client, kicked him, knocked over a defense attorney who was standing in the path, had to be drugged from the courtroom by deputies and KBI agents. The state would have you believe that this was akin to wearing buttons or some sort of outburst in the audience. But what happened on that day in that courtroom was an independent crime. And we are asking the jury...
What's the evidence that the jury was prejudiced by the conduct?
By my client being tackled in open court?
What evidence do you have that they were prejudiced somehow?
Who wouldn't be? I think that this is one of those cases where I don't actually have trouble standing up here. I know we're under an abuse of discretion standard, and we have a little bit of extra Eighth Amendment protection here, I think. But this is one of those cases where I don't have a problem standing up in front of this court and saying that no reasonable person could do what that trial judge has done. And to show that, I think we can look at the case law over the last 40 or 50 years. There's not one case. We researched this when we filed the brief. We researched this for the reply brief. We researched this for 609 purposes. I sent out an all-call to basically every capital defense attorney I know on our listserv and said, who's seen a case like this? Tell me what happened. There is not a single appellate reported case that we could find, and I don't know what your clerks have found, where a defendant was actually physically attacked in court and the defendant did not bring that on himself. There's just not one. Now, the state cites two cases. We're arguing that those are different. The Blackwell case, first of all, wasn't in open court. It was in the hallway, and it was actually kind of a melee that was started by the defendant's supporters. That's different here. The Diaz case was actually in court, and some jurors saw it. That was 40 years ago, and it was also non-capital. And this is not an issue where, we are arguing that Eighth Amendment protections apply generally, but this is not an issue where it's just some sort of magical cloak that's out there. This is an actual, we need one juror in these cases, one juror. And that's different from the Diaz case where it was a rape case. Those are the only cases that the state could find where a defendant was actually physically attacked in the courtroom. And like I said, I think that those are both pretty easily distinguishable.
Ms. Carver-Allman, it appears that there's little dispute over whether this was a fundamental flaw in the proceedings, which is your first hurdle on mistrial. But as my colleague alluded to, your second hurdle is that it was an uncurable kind of event, or that whatever measures were taken were not adequate to cure. What was inadequate about the way the district judge handled it? My understanding is that they immediately ceased proceedings, removed the jury from the courtroom, and that there was a fairly lengthy colloquy between the court and the jurors afterward to inquire whether they were affected by it. Have I got the wrong issue, or is this?
I don't know if I would call it lengthy quite, but
okay. You
reasonable
made a face,
people
so
may
I thought
differ.
maybe I was off on another issue. Okay. There was a colloquy. There were several questions asked. The answers or responses that are recorded in the record indicate the jurors said they were not moved in the way that you're suggesting they were moved. So what more should have been done other than, could anything have been done short of a mistrial?
No. And that is our point here, that this was something that was so bad, and that's again shown by the fact, I guess you could argue a couple of inferences from the lack of appellate case law, but we are arguing that the utter lack of appellate case law on this situation shows that I don't think it's that this doesn't ever happen. I think that's when it happens, reasonable judges grant mistrials. I don't think that there's anything that we could have done to wipe that from the jury's mind. There's nothing that we could have done. And on the
How do we get there? I mean, the jurors affirmatively told the judge that they would set it aside, well, at least by nodding their heads when asked. We usually presume that jurors follow instructions. I mean, how do we overcome all of that?
But there are mistrial cases where we've had an admonition, we've had the juror say, yeah, we can put that aside, but we agree that it's whatever happened was so bad that it just can't be overcome. And that's what we're arguing here, is that
And why is this so bad? I mean, it obviously demonstrates a very high emotional level, deep-seated feelings, but and it goes another step in that it shows a physical aggression as opposed to somebody being in the audience and sobbing, or we have lots of situations where they cry out. I mean, the only difference, and lots of those cases where they say no need for a mistrial, the difference here is that this person took it a step further to the physical aggression. But does that in and of itself mean that it can't be cured? When you know that there is deep emotion. I mean, every juror in that courtroom had to know there was deep emotion.
I guess I disagree with your use of the word only there. That seems like a pretty big step to me from an outburst, or again, the state compares it to wearing buttons, which I think is just sort of silly, to an actual, this was a battery. This was, in some jurisdictions, I think you could charge this as attempted murder, for goodness sakes, that happened in front of the jury. And I think if you've ever been in the room where a fight occurs, your adrenaline gets going.
I've been in courtrooms.
I'm sure you have. Yes.
I mean, if you've been on the trial bench very long, you've experienced something like
Some
this
sort of physical aggression.
in your courtroom.
Yeah. And
those do not always end in mistrial.
they don't, but it's also, you also, I think, have to look at the fact that this was a capital penalty phase. Again, one juror. And it let in, and to kind of shift just slightly, it let in evidence that would not have been admissible. The clear, I think, implication from Mr. Williams' attack on Mr. Kleypas was, I want this guy dead. I want him dead. And he would have never been permitted to testify to that. He never could have gotten up and offered that opinion testimony under Booth and under Payne. That's just not allowed. And so it let in, not only was it prejudicial in that it was a physical attack on my client in the middle of the courtroom and all of the emotions that go along with that, but it also let in evidence that there is no way the state could have gotten in any other way. And just to answer a few of the points that the state made, the state is also arguing that nobody knew who that really was. And I would submit that Mr. Disney, the prosecutor below, said it's probably obvious who that was. And even if the jury didn't specifically know that that was Miss Williams' father, I think they probably knew that, I don't think it's sort of a distinguishing without a difference to say it was her uncle or her cousin or whoever it was someone who was with her, obviously, and very upset. And also, I think, kind of in evaluating the district court's decision, this case, we have to remember this is probably the last capital case in Kansas that will ever get a change of venue granted. So the district court was, not sleeping in his own bed at night or traveling, I don't know which, honestly. They had just gotten through jury selection. They were tired. Nobody wanted to start this over. And that kind of puts a thumb on the scale of, let's just push through. And I think that they pushed through when they should not have pushed through. If there are no other questions on that issue, I'd like to move on to the Fourth Amendment issue. And this one, I think a lot of our argument is on whether the court can even get to this issue, and I think we've addressed that. I've said about what I can say in our reply brief, which is that this is still a live direct appeal, so res judicata doesn't apply. And as to the law of the case contentions, I think there's some intervening case law that clearly dictates a different result, so that is why we can go back and reach it.
You're in a kind of difficult position today in that sometimes you want to use the law of the case is a shield, and sometimes you want to use it as a sword. The state is, on this side of the bench, we often like some test or some standard or some rule, some checklist that gives us some assurance that we're applying the law uniformly, fairly. And the state's given us something here, which is convictions are solid, we're done. Anything that's in the sentencing phase, law of the case doesn't apply. And I know you disagree with that, but do you have any other hallmark of where the law of the case, where we draw the line and why we should apply it on some of your issues, why we shouldn't on others? Is it just because you don't like the outcome? We need something different than that, I think. So what is that?
I think partly there's an intervening change in law in this issue and in issue 2 that applies to those 2 issues. The other issues that are kind of the direct appeal issues reserved, we aren't actually arguing that the court should reach those today. We included them in the brief for cert purposes, but I think law of the case does dictate not going back into those. We felt like we needed to reassert them just again for certiorari purposes. And then as to issue 9, I think it is, which is the equipoise instruction. I think in that issue, it's a question of a lower court having to enforce a higher court's orders versus this court being able to reconsider its own orders. So the district court, without doing something to try to change the mandate or something like that, I don't think that the district court can ignore an order from this court. Whereas this court, I think, is free to reconsider its own orders. It's sort of like if a district court, I had a case actually a few years ago where a district court made a decision on a motion to suppress, and then a case came down from SCOTUS before trial that basically totally flipped the analysis. And the state reasserted their motion, and the court said, yes, well, now you're right, and that, I think it was a confession, I'm not sure what, but that comes in now. So it's sort of like, because we didn't have a sentence, which is a final judgment in a criminal case with very limited exceptions, which we're arguing don't apply here, we don't have a sentence yet. So the case isn't over yet, and you can reach back in and touch those things. And really, it's our position that if you decide that you can't reach it, then we'll file a cert petition and take it up to SCOTUS, and they will summarily send it right back to you. So that's sort of just silly to have to go through that waste of time and process when we could just fix it right now. So that's kind of our position on that. And then once we get to the actual Grow issue, I think that this case is factually completely indistinguishable from Grow. I think if you look at particularly, the state argues there's some differences, but particularly if you look at the dissent in Grow, it was sort of questionable what the officers told the homeowner in that case, but it wasn't really questionable what the officers told the other officers. And if you look, Justice Thomas and Justice Kennedy clarify that Justice Thomas says, prior to the execution of the warrant, the petitioner briefed the search team and provided a copy of the search warrant application, the supporting affidavit, and the warrant for the officers to review, which is exactly what happened in this case. And, SCOTUS has said that is not okay under the Fourth Amendment, and it's not good faith. And I think that there's no reason for this court to be able to distinguish this case from that. So I think if you can get to it on the Fourth Amendment issue, which again, we argued that you can, then that part of the result is, that's just what has to happen.
What do we do with the language in the majority, though, that says they're not reaching the aspect of what would happen if the warrant had been incorporated, or the affidavit or supporting document had been incorporated and had been at the scene?
They're talking about, if you read it really carefully, the majority opinion is talking about the oral pronouncements that were given to the homeowner in that case. They don't talk about the pronouncements that were what the officers amongst themselves said, which again, that's the part that the dissent clarifies, I think. And in this case, of course, my client was not there when they were searching his apartment. So that's not even an issue. What we're talking about is what the officers told the other officers. And in this case, they brought the warrant to the scene in Grow. They brought the warrant application to the scene. The affidavit. And they went over it. And as far as good faith goes anyway, in this case, I think this court has to look at what actually happened here. First of all, this is a requirement that's contained in the text of the Fourth Amendment itself. It's not like we're pulling something out of the sky here. Second of all, these officers, they realized their mistake before they went in, and they just decided to go in anyway. And not only did they decide to go in anyway, they decided to go in and collect 117 pages of inventory transcript worth of items, most of which were not identified in the warrant. They were supposed to be going in for trace evidence, for blood, for weapons. They collected boxes and boxes of documents and photos and jewelry and money and video cassette tapes. So I think, and most of that was suppressed, admittedly, but I think we can look at that in assessing the real intent of the officers
Counsel,
here.
Assuming that you're right about being able to reach it, that you're right that it was error, that it's not excused by good faith. Let's just assume all that.
We're going to harmlessness
Why
now.
does that matter? Yeah, why does it matter? Isn't the only piece of evidence introduced a stain from a shower curtain?
It's the shower curtain, which was a mixture of Miss Williams and Mr. Kleypas's blood. That was used by Dr. Logan to show that Gary's confession wasn't confabulated, that he hadn't just filled in the pieces. So we think it was
Wasn't there a
important.
ton of other evidence that tended to indicate that?
There was a lot of evidence in this case. About the best thing I can point to as to that was that the state below certainly thought that it was reversible. I think if you look at record 24, page 100, when they were looking at this for the penalty phase, the prosecutor said, well, if Groh applies to keep the evidence out now, then the whole conviction is bad. So
We don't necessarily, we're not necessarily bound, of course, by party's legal concession.
no, I think it's indicative. You're certainly not bound. That's absolutely right, Justice Beyer.
Okay, thank you. Did you start to say something? I'm sorry.
I think you misspoke when you said that they collected items that were not described in the warrant because there was nothing described in the warrant, correct? You were
Exactly,
talking about
Justice
the
Johnson.
affidavit.
Exactly.
Okay.
Exactly.
Just to be sure I understand your argument, this is only a guilt phase argument. It has no impact or effect on the penalty phase?
They suppressed the evidence from Gary's apartment in the second penalty phase. So, I mean, I don't think we have any argument there because the district court looked at Groh and decided to suppress it all. So I don't think that there's a problem as to the penalty phase.
Okay.
Those were the two big issues that I wanted to touch on. Now I kind of would like to just go through a couple more issues and there are a couple places where I feel like the state is mischaracterizing our argument. So I kind of want to just go through and clarify some specific points. And first of all is this, the categorical challenge based on mental illness. And the state says that we're not really picking a category here that's part of their problem with our claim. And I say that the category is exactly what we've always argued it was. It was what we argued below, and it's in our brief too, and it's what the ABA also incidentally says it should be, which is that list of the mental disorder that significantly impairs capacity to appreciate the nature of conduct, to exercise rational judgment, and to conform conduct to the requirements of law. It is not as easy to figure out as like IQ is, I think. But I think if you look at what they're having to do with IQ now, that's not terrifically easy either, because you're always figuring out from a range of things what a person's IQ is as far as developmental disability. That categorical challenge has gone.
I have a question about this
Sure.
argument. This is totally based on the Eighth Amendment. There's no state constitutional component to your categorical claim.
We raised the state constitutional component as a separate issue, and basically that issue is based on the or in the Kansas
Right.
Constitution.
That's why I'm asking. On the one that is focused on having a new category of people with severe mental illness that lead to these various impairments, that's made solely under the Eighth Amendment.
I believe that our Section 9 issue incorporates the Eighth Amendment issue.
Okay.
So I don't want to say that. I don't want to give up anything there, I guess, on that. But
That leads to the further question of what a categorical challenge under Section 9 would look like.
I'm not sure, to tell you the truth,
Yeah.
Justice Breyer. I don't think we've had
An
one.
argument about it.
Yeah.
Okay. All right. That's all I have for now.
Okay. So that's our category.
How are you it sounds like you're really relying on the ABA statement of the category.
That's, I mean, again, that's what they argued below, and not that we're necessarily stuck with what they argued below, but I think that that's a decent category. The ABA says that that should be the category. I think several other mental health professional associations have kind of coalesced around that definition or something close to that definition.
But doesn't the ABA discussion of that piece and the comments make it pretty clear that it's a case-by-case evaluation? And if so, how do we apply a categorical challenge?
That article that I think you're referring to does suggest a case-by-case determination. We're arguing that that would be inappropriate because, first of all, for all the reasons that we don't execute people with developmental disabilities, people under the age of 18, we're arguing that basically the categorical protection is necessary because doing it on a case-by-case basis would be under-inclusive, and presenting mental health evidence a lot of times the same way it is in Atkins, in Roper claims, it can be a double-edged sword. This person, my client even, let's just go to this case at hand, his mental illness obviously causes him to act in some very violent ways. So is that mitigating or is that aggravating? A jury could see it either way.
So how would this work? This is my other question. I jotted down on this. How would it work? I mean, obviously, if you've got a developmental disability issue, at least there's some quantification attached to that. There's argument about it, but there's some quantification that a person is or is not younger than 18. That's just a knowable fact. So are you suggesting this would be a judicial fact-finding of some sort before trial, or it wouldn't be left to the jury if it's categorical, right?
Yeah.
So how would that work? How would it work?
I think the way that it's being done in the IQ cases, again, which are the best analogy I have, is that there is a pretrial judicial finding, and then they go from there.
Evidentiary hearing.
Yeah,
followed by
evidentiary hearing.
A fact-finding and then a ruling by the trial.
Yeah. And that's actually another thing that I wanted to touch on here is I think we have a real problem with the district court's ruling on this issue because it's not really a ruling. He says, there may be some merit to what the defendant's indicating, but basically, I don't want to decide this issue. I'm going to leave it for a higher court, which I don't think that courts are really allowed to do. I think that if an issue is presented in front of you, you're supposed to decide it.
But it leaves us with no factual finding.
Exactly. So
Go ahead. It sounds
I
like
think a
you-
remand is appropriate.
Why, when the defense didn't I mean, we've put some burden on the parties if factual findings are not sufficient for appeal to push that issue. Why should we ignore that?
Well, first of all, and I believe you're talking about Seward. Seward, which made that very clear, and that's kind of where this court has set the line, frankly, was decided in October 2009. This hearing took place in October 2008. So this was, we haven't, keep in mind, I guess, basically that this hearing happened a long time ago. And before we've been kind of illuminated by a lot of this court's case law on that subject. And also, I think,
I think we were harder in Seward and said, look, let's, but it wasn't like Seward just came out of nowhere. There was quite a bit of case law before that.
I would argue, and I disagree with Seward, frankly. I'll say that because I think it puts defense counsel and prosecutors sometimes in a very awkward position of having to force the trial judge to do something. And unfortunately, we don't have much power to force judges to do things that we want them to do. I think they filed a motion. It was a well-argued motion. It wasn't just a cursory motion. It was, I think, in the realm of 10 pages. We argued the issue. The district court needed to make findings. And basically what we're asking for here is a finding that Gary fits the category. And I think that there's plenty of evidence that he would fit the category, but we just need that official determination. And I think that we need a remand for that.
Another practical question is, what access will the state have to be able to do its own mental evaluation in order to to use that as evidence to counter whatever the defense would present.
I think that that's something that would have to be fought out below. I don't know that that's really the issue in front of this court right now. Again, it's
Well, I think it is to the extent of, is the line back where the defense is asserting a mental incapacity defense? Is that where we draw the line?
it's definitely different than a mental incapacity defense. I mean, we're arguing something different, right? We're arguing, again, I keep saying this, but again, as in Atkins claims, as in Roper claims, we're not arguing that that my client is exempt from criminal responsibility. He's guilty, but we're arguing that that for reasons inherent to his personality, inherent to his mental makeup, he's less culpable. And that's, again, that's the same thing as the age and IQ cases. So I don't think going back and setting the line at mental disease or defect is necessarily appropriate. But that's actually not something that I've thought out all of the way. So I don't know that I can say much more on that.
Counsel, previously on categorical challenges, the U.S. Supreme Court has indicated that one of the prime places to look for whether we have an evolving standard of decency kind of argument is what state legislatures are doing. And I think the count is radically not in your favor. And there's only one state where the legislature actually said we're going to exempt from death penalty folks who have mental illness at the time of the crime, and now that state has abolished the death penalty altogether. Am I right about that?
You are right about that. I think you're setting the frame too small. I think yes, and to be fair, yes, the Supreme Court has placed a lot of weight on that state by state analysis, but I think they have counted in that analysis states that have abolished the death penalty altogether. So I don't think just because Connecticut has abolished the death penalty altogether means that we just can't talk about them anymore.
Is there someone other than Connecticut that has said that these folks are going to be ineligible?
Not that I'm aware of.
But are you saying that the states that have abolished or not adopted a death penalty would be included in those that choose not to execute mentally ill persons because they choose not to execute anyone? Is that your argument?
Exactly, Justice Johnson. And not only, I think we're at 3119 death penalty versus not death penalty states right now. But I think the Supreme Court has also indicated that we can look at the rest of the world. And most of the rest of the world does not execute mentally ill people. And we can look at those statements from the ABA, from the American Psychiatric Association, etc., all cited in our brief. That there is a developing consensus that we should not be executing people who are mentally ill. And I think if we limit the pool to states that have the death penalty already, we're getting ourselves into a pool that's not a pool I want to be in, frankly. So we're kind of limiting things to the lowest common denominator there inappropriately. I'm going to move on if there are no more questions on that, to issue 10, which is, wait, I flipped to the wrong page, which was the defense request that Mercy be an enumerated mitigator. And this is one of those issues, I think, where the state is arguing that we're kind of arguing out of both sides of our mouth, because we argued in Kleypas 1 that Mercy shouldn't be considered in that way. But actually what we're arguing in this issue is that in Kleypas 1, in Scott and Cheever, this court has told us that that is where Mercy is to be counted in the calculus. I don't personally know that it makes a lot of sense, because I think if you view it as like these scales that you have, mitigators on one side, aggravators on the other, you've got your neat little blocks of horrible childhood and whatever the aggravators are, and Mercy is sort of like this, 10-sided dice or something that you throw in that doesn't really go. But our argument is that the court has said that that's where Mercy goes. It goes on that side of the scale when we're putting on aggravators and mitigators. And our argument is simply that if that's where it goes, then that's where it goes. And if it's going to be a mitigator, we have to treat it as a mitigator. And I'm aware, and the state argues, that there's federal law that says we don't have to have a Mercy instruction at all. But we are arguing that under Kansas state law, we've said it's a mitigator. The defendant here was alleging that it was a mitigator. So therefore, if that's where it's supposed to be counted in the calculus, it should be listed in that list of mitigators.
In fact, in Kansas versus Marsh, the Supreme Court said some things that made it pretty clear it liked that instruction. It said some favorable things about the way it was worded.
About the catch-all provision specifically?
Well, not the catch-all provision, but the mercy instruction in general. And so if it does meet the federal constitutional standard, what's the basis for your argument? I mean, I know you say state law, but isn't that in Kleypas 1, to reach the decision, it cited this federal cases, as I recall. It didn't cite state cases.
Well, it's state law informed by federal law, I guess is sort of the way I'm thinking of it, which is, okay, so the federal law says that we have to present to the jury basically any mitigators the defendant wants to present. The defendant has to be able to present that. This court has said...
Let me stop you right there.
Sure.
But federal law does not say mercy is a mitigator.
No,
Is that what you're saying?
but this court has.
Well, I understand that, but that's why you have a hybrid law, because the reason federal law informs our law is that we've said mercy is a mitigating factor rather than a standalone concept
Sort of outside thing.
as a matter of grace, which makes more sense. Mercy is not something that reduces the culpability or morally or legally. It's simply an act of grace for someone who has not earned it, isn't it?
Exactly.
But we have said it is a mitigating factor along with those that are proffered to suggest less culpability.
Exactly. That's you've restated my argument perfectly, Justice Johnson. And I think the difference here also I wanted to touch on between just the general catch-all provision and it being actually listed in that list is I think we have a very long-standing tradition of Anglo-American law that to get mercy you have to ask for it. You go back to the king, and before a beheading, the accused was allowed to stand up and beg the king for mercy. And I think that's why it matters here. That it is in that enumerated list of these are the things that the defendant is asking you to consider as mitigating evidence.
If the defendant had not listed mercy in the long list of mitigators, could the state argue that defendant's not even asking for your mercy?
I think so. And then, again, just kind of going through a couple of problems I had with the state's brief. This Horn issue 19, which was that the district court didn't try to recall the trial jury before impaneling a new penalty phase jury. I think this tracks exactly with Horn. I was joking with Ms. Johnson actually before all of this. I don't know why this issue got stuck so far in the back of the brief. I love this issue. I basically, Horn said shall be in front of the trial jury. And the state's arguing that nothing in Kleypas 1 ordered the court to conduct resentencing in front of the original jury, but the statute actually does. And nothing limits the court authority to order a new jury, but the statute says shall. And also there's this Wavell estoppel argument that they raised, but in Horn, actually, the defendant invited the error and the court still reached the issue. The defendant in Horn actually asked, after he had waived his jury trial, actually asked for a jury for the upward durational departure proceeding. And this court still said, it doesn't matter. It's not permitted by the statute. That's not how we do this. So we're arguing that this case needs to be remanded for at least some effort at recalling the original jury under this statute. And
How would that work? I mean, functionally, how would that, even now, but take a step back at the resentencing hearing, how would that work? How many years after the trial and the first sentencing was the resentencing? I think it was 3 or 4, wasn't it?
Oh, goodness. I think Kleypas 1 came down in 2001, and this was happening in 2008-ish. So
Okay, so we have
general.
7 years at least that have passed. How is that supposed to happen?
You look, you try. I mean, I guess that's the point here. And yes, maybe they would have looked, maybe they would have tried, and maybe they would have not been able to find those jurors. Maybe they would have died, maybe they would have moved. I don't know, but they didn't even try.
And,
is
and
the
then you
point.
have the whole functional part of it is that when a jury is impaneled, there's admonitions. 7 years have passed of talk of what's happened in this case. Probably each juror has discussed their experience. Most likely, admonitions have been violated right and left in this. How is that supposed to work?
The statute says shall, and that's all I can come back to, Justice Rosen, is that this is what our legislature has told us we have to do. And actually, after Horn, if you set out the statute now, the capital version of the statute, and the statute as it was in Horn, they've actually amended the statute since Horn to kind of fix this, but they didn't fix the capital statute. So I don't know what this court is supposed to do with that. We're supposed to do what the legislature tells us to do, and they say that we shall try to get that original trial jury back together, and if we can't, then it provides a procedure for it. But they say shall.
It does give a Plan B,
Right.
the statute.
It does.
So where do we look in the record to know that there was nothing done to try and reassemble the original jury? Is it discussed anywhere?
It is not discussed anywhere.
So
And
doesn't that mean you have an evidentiary problem, just a record on appeal problem here? And I understand we're supposed to look at every issue, even if you don't raise it, even if you've not raised it below. I get that capital cases are different that way. But you still have to have a record to support an issue, and there's no record here to support your issue.
and my rhetorical question to that is, how do you prove a negative? How do you prove something that didn't happen? We ask that
But you don't assume it did.
Oh.
I mean, that's what you're asking for. I'll just say in response, you're right, proving a negative is hard, but that doesn't mean you just assume it did happen. That's not the logical outcome.
We asked that every hearing in this case be transcribed.
And none of those
And none of
transcripts
is
show that this was ever discussed.
nowhere in the record that it was
But that
discussed.
doesn't mean that something else didn't happen. I just think you've got a record problem maybe here.
I don't know how else to prove that it did or didn't happen other than looking at the record and seeing that it didn't happen.
Okay.
Well, you raise an objection.
And
And no, there was no, I mean, isn't that the point of the objection rule, is so that records are made? So is this a situation where we do have to put some burden on the defendant for failing to raise the issue below?
I think that that's maybe where the capital preservation statute comes in, that this court can consider assigned errors regardless of objection or lack of objection below.
But doesn't that require us to review the record? And again, there's nothing in the record that would tell us that this happened.
And there's nothing in the record that would tell you that this happened. I mean, that's,
Either way.
you have the whole record and it's not there. I don't know how else to prove that it didn't happen other than just to cite to the whole record. If there are any further questions, I'd be happy to answer them.
Is anyone else? Oh, no, on that point.
Oh,
Okay,
you-
go ahead.
You have no further presentation, is that correct?
Exactly, Justice
Oh,
Hess.
okay, then I might have a couple more. Hold on just 1 second, please. Bear with me.
On the what the state labels as the collateral attack on the Missouri conviction, there's some indication in the record that there was some activity, a habeas action or some other activity in Missouri. Does the record establish what happened with that, or is that a matter of public record that the court would take judicial notice of? What's the status then?
There is nothing that I'm aware of. I think you're right that something was filed, but I don't think that anything became of it. I will certainly, what I can do on that is I can go, that's something I would have to go back to the office and check, and if I do find anything, then I can of course let this court know.
I was thinking could we assume that he was unsuccessful in his collateral attack, since we haven't heard otherwise? I would think you'd be jumping up and down if you'd heard otherwise.
I'm pretty sure we'd be shouting that one from the rooftops.
Right, right. So I was thinking we could just assume that hasn't
I
happened.
mean, again, I will go back and check.
Maybe a
but-
dangerous assumption, but I would think you would have let us know if that had happened.
Yeah.
And is that pretty I mean, if that is true, is that damning? I mean, is there anything left to your argument at all, if that's true?
It's not good. You know, obviously it would be easier if we could have gone back and collaterally attacked the Missouri conviction in Missouri. And unfortunately, I mean, if you look at this, I think Strickland didn't even come out until 8 or 9 years after this conviction in Missouri. So I think it was just, you know, it didn't get challenged at the time, and then, you know, we get barred by timelines and those kinds of things that put a stop to those issues. So, you know, our argument is that it's still an unreliable conviction and Kansas shouldn't rely on it, but I understand what the law is on that issue.
Any further questions?
Yes. I have, I think, just one more. And it kind of goes back to what we talked about a moment ago. It's at least related. It's not the same. I asked you if you had a Kansas constitutional basis for your categorical, and if you did, what would it look like? And we had that back and forth. Now I want to ask kind of a similar question about what we do with some other type of proportionality challenge under Section 9. Because we've said repeatedly that Freeman doesn't apply to, it applies only when you have a term of years sentence. So what does it look like? What's the analysis pattern?
Okay, so you're talking about like a Freeman challenge.
Well, what would be a Freeman challenge were it a term of years? But it's not term of years, so it's not Freeman. Is there some portion of Freeman that should be applied in a capital case or not? I mean, I don't see any argument about that.
Yeah, I mean, the problem with raising a case-by-case challenge, as I understand it, and I'm just totally off the cuff here, is that it certainly has to be raised below, and it wasn't here, obviously, so it wouldn't be something we could raise on appeal.
For your issue then, that there should be a Section 9 proportionality challenge? Isn't that a non-categorical proportionality challenge under Section 9? The fact that it wasn't raised below, is that a dead end for you?
I don't know that it is under the capital preservation statute. But certainly,
That's the problem.
I don't want to argue you out of this.
Yeah.
But
I'm
certainly,
just asking you, what does it look like?
we
If
have
you
to
want
have a
us to do
record.
it, tell us how to do it.
I mean, I think to look at the Freeman factors and just, you know, again, just pulling the Freeman factors out of my head, you know, we'd have to look at the
Comparison to other crimes in Kansas.
The comparison to other crimes in
other
Kansas.
places.
the defendant's individual culpability. And I think we would need district court findings on the first Freeman factor, at least, if not the other two. So if you know, certainly we could remand for those findings. And I think that, you know, looking at our argument as to mental illness would apply to make this crime less severe as far as capital murders go. So I guess that's, again, just kind of off the cuff
But
about the best I could do with that.
The problem here is we're trying to apply a disproportionate sentence to a challenge to the methodology, to the method of punishment. And we've said Freeman doesn't apply to a cruel or unusual method of punishment. So how do we look at the methodology issue? We really don't have anything that I'm aware of in this state where we've talked in those terms.
I think, and I mean, there's certainly something in the capital preservation statute that's ringing bells in the back of my head that this court can consider the sentence overall. So maybe that's a way to get to it.
I'm just trying to figure out some sort of analytical pattern that would contain our whim, and I'm just not hearing it.
Let me think about that a little bit and maybe get back to you on rebuttal if I can think of something more.
Okay,
I'm having trouble off the top of my head here.
thank you.
Any further questions? Thank you, counsel.
Thank you.
Counsel, before you approach,
May it please the court, Chris Elslager appearing on behalf of the state. I guess I want to begin with just a brief recitation of the procedural history of this case. In 2001, as this court knows, the court affirmed Mr. Kleypas's convictions, but remanded for a new sentencing proceeding. We've had that new sentencing proceeding, and now two juries in two different proceedings have unanimously agreed that Mr. Kleypas deserves the death penalty. And I recite this for a couple of reasons. First, because as the court has already acknowledged, the first 6 issues that the defendant raises are guilt phase issues that were decided and affirmed in his earlier appeal, and were no part of the remand proceeding, the resentencing proceeding, and are not properly before this court. And second, I think when we get into issues of prejudice and harmless error and so on, I think it is informative that now we have had basically a super jury of 24 jurors unanimously agree that Mr. Kleypas deserves the death penalty.
Well,
So-
maybe you can start with that second jury and counsel's point that the statute says shall be in front of the trial jury. What functionally happened here and what is supposed to happen?
Well-
Given some of the concerns, or at least some of the issues I raised, with just the practicality of
Well,
that.
practically what happened is the court reversed and remanded for a new sentencing hearing, 7 or 8 years after the original trial, because there were errors the court found in the sentencing proceeding, and that original jury was exposed to errors that, in the court's view, rendered its verdict questionable, and it remanded to the district court to hold a new sentencing hearing, and that's what the district court did. Now, with respect to the language of the statute, if you read it, I mean, you can clearly see the statute really is contemplating what to do following trial. And that's all it addresses. Following trial, the same jury will continue to hear the proceeding unless they can't, and then there's procedures for the court to appoint alternates or seat a whole new jury. The statute doesn't speak to what to do on remand. It just doesn't apply.
Before we go on to the legal argument, I want to just back up 2 sentences to the facts. Are you saying that the trial court did not make any effort to reassemble?
Well, I don't know.
As a matter of fact, you don't know.
The
Okay,
record, and that's part of it.
I
it's
hadn't
like-
seen any assertion that, yeah, that is what happened, so I wanted to make sure I understood what you're saying. Okay, thank you.
Yeah, we made that argument in the brief that we really don't know what happened below. I mean, for all we know, that there was a discussion in chambers, and I would suspect that if the judge had suggested that he was going to try to reseat the original jury, that the defense would have jumped up and down and screamed bloody murder. That no, you can't do that, because that's the jury that just had imposed the death penalty on their defendant. They would absolutely not want that same jury to reconsider the same issue. I mean, that quite honestly,
The AG wasn't involved in that?
No, the AG's office was involved in the. I mean, we handled.
But it's just not of record.
But it's
So
not
the
of
AG, the AG knows what
Well-
happened, it's just not of record, right?
Well, I don't know.
Okay.
I'm going to tell you that right now. I don't know what happened below. I think the record isn't there. If they really wanted that, if they wanted the original trial jury sat, I think the defense should have raised an objection and asked the judge to try. But quite obviously, as a practical matter, the defense wouldn't want the original trial jury. In fact, in the first case, they argued that the trial jury should not have been the sentencing jury. They wanted a new jury for the sentencing phase. So in effect, through the remand, they got what they wanted.
And as a practical matter, or as a legal matter also, that trial jury was discharged.
Yes, it was.
It was discharged from duty, and so there no longer was a trial jury unless it had been recalled, and then it would be a new jury, same people but a new recall.
Yes, and I think the voir dire of that would have been very interesting, and I think there would have been a lot of challenges for us. Since they'd already decided the case once. So I think that again, I want to reiterate, I don't think the statute applies because it doesn't address this issue. It doesn't address what to do on remand.
But that was really what happened in Horn, wasn't it? That there was no trial jury, which would be akin to here. If it's discharged, there's no longer a trial jury. But that didn't stop the decision in Horn, the fact that there was never a trial jury?
Well, I think in this case, I think we had a remand order from this court directing the trial court to conduct a new sentencing hearing, and it followed the court's mandate. And the statute really addresses what to do following trial, and it does provide a procedure for seating a new jury. So even if you were to say that the statute applied, I think we can all recognize as a practical matter that the original trial jury could not be reseated.
Mr. Esliger, you were getting ready to make kind of a little more of a legal argument, I think, on the statutory language, and when we first started interrupting you with questions. Do you remember where you were, or do you want me to try to prompt you?
You might want to try to prompt me.
Okay, alrighty. The sentence you just, I think you were just referencing as you closed up there was, if any person who served on the trial jury is unable to serve on the jury for the sentencing proceeding.
Yes.
The court shall substitute an alternate. Now, that sentence you think applies directly after trial? Because it strikes me that that sentence could apply here.
I think
when
it
you
could.
have a situation where everybody's been discharged and then none of them is able to serve.
I think it could apply here. In fact, I think I argue in the brief that as a matter of law, it should be as a matter of law that the original trial jury could not resit.
For having been discharged and for having sat and arrived at a death penalty under tainted proceedings, or what were
Yes.
determined later to be
Yes.
tainted. Okay, thank you. I just wanted to make sure I had a handle on your statutory argument because we didn't let you make it before.
Thank you. And if there are no further questions on that particular issue, I'll move to the mistrial argument. I think certainly the way that the trial judge handled the issue was appropriate, and that his decision was not an abuse of discretion. The judge took several steps to mitigate and ameliorate the situation. He banned the victim's father and the former fiance, who apparently caused some kind of ruckus in the hallway, banned them from the courtroom, placed additional plainclothes security in the courtroom. But then what's more relevant is that he admonished the jury that they were not to consider what happened in their deliberation, what they'd seen in their deliberations, and it should not be held against either the state or the defendant. And we presume that jurors follow their instructions. And also he polled the jurors, asking them if the incident affected their ability to be fair and impartial. And they all indicated that the incident would have no effect on them. So
Did he actually poll individually? I thought I had the
he
idea
polled them
that
as a
it was-
group.
Oh, yeah, I thought it was all together. Yeah,
Yes,
it wasn't.
yes.
It wasn't polling in the sense that was this your verdict, right? Okay.
Right, he not separate, but as a group, he asked them, and I think it's no different than in voir dire when you ask jurors if they can set aside whatever they've seen or heard and decide the case fair and impartially. And if they, say they can, we don't disregard that.
Sometimes that kind of thing takes a while to kind of set in, though. I mean, I know that if I recall reading, there was some suggestion that we should even send them home and then see what happened, for the day. And the judge declined to do that.
Well, I think that could
I mean,
even
how
exacerbate
do-
the situation, because that would kind of highlight it that would make it seem like it was a bigger deal than it was.
But what guarantee do we have really that,
Well,
that
we don't
because
have.
it was a very charged situation and probably scary. I mean, I think Mr. Disney or maybe defense counsel made that point that the jury likely was afraid for themselves even.
I don't know, but I'll tell you, we don't have any kind of guarantees. That's impractical. There's no guarantee. But what I will say is that this court has recognized over and over again that a significant factor that appellate courts note is the superior position of the trial judge to observe the events. He observes the demeanor of the jurors and considers, what the trial judge is there in the courtroom, and he sees what happens, and he can best assess, how it affected things. He can determine how much people saw. He sees the jurors as he talks to them, and he can make the determination about how it affected them and so on. He's in a much better position than any of us are here. And this court has noted that repeatedly when deciding issues of requests of a mistrial.
Does the heightened scrutiny of death penalty change our ward standard of review on this?
I don't think it should. Quite honestly, I think that the heightened scrutiny mantra gets a little bit misplayed, because quite honestly, due process is due process. If the death penalty requires something more, I think that's saying then the people who aren't capital defendants aren't getting what they deserve, and that's not right. I mean, the process is the process. It's always the same. We always provide all defendants with the same guarantees, the same constitutional rights, the same fair procedure, whether it's a capital case or not. So, no, it shouldn't change the calculus. There shouldn't be any additional, anything additional because it's a capital case, because all cases, we treat all cases the same. We provide all defendants with the same level of due process, the same protections, the same fair trial guarantee. The fair trial guarantee isn't different for a death penalty case as it is for any other case. So when the trial judge is sitting in the courtroom deciding whether the defendant's right to a fair trial has been prejudiced and they can't go on and it has to declare a mistrial or not, the standard is the same. It's a fair trial, and the trial judge is in the best position to make that determination because he can see what happens. He can see the jurors, he can see the defendant, he can see the attorneys, he can see everything. And he can make that firsthand assessment that we sitting here, years after the fact, reading a cold record can't make. And that's why the court heavily defers to the trial court's judgment, and that's why the standard is abuse of discretion. I mean, it has to be so unreasonable that no one would agree with the trial court. And I don't think you can make that statement here. To do that, you really have to engage in some major speculation about what was in the minds of the jury, and you also have to speculate that they ignored the trial court's admonitions and that they lied to the judge when they said that they could be fair and impartial. And I don't think you can credit that kind of speculation and overturn the sentence.
As long as heightened scrutiny has been mentioned, how does that play then in the harmless error analysis? Everyone's entitled to due process, but if they've been denied due process, is everyone subject to the same harmless error analysis?
Yes, the harmless error is a little bit different in the death penalty sense because when you're looking at weighing aggravating and mitigating circumstances, I acknowledge that it is a bit more difficult as opposed to seeing whether elements of a crime have been proven, which is generally the case. You're looking at harmless error and say, well, there's clearly enough evidence here that this element was proven regardless. But when you're looking at weighing of aggravating and mitigating circumstances, I will acknowledge that that is a bit of a less objective kind of view. So in that sense, yes, I do acknowledge that the harmless error analysis is different.
Especially when you inject mercy,
Sure.
which would allow a juror to vote against the death penalty just because they feel like an act of grace today.
Exactly. Yes. And I think, quite honestly, this incident could have cut both ways, too. I mean, this could have been construed by the jury against the state as well. So I think, again, we go back to longstanding rule that we defer to the trial court's judgment because he's in the best position to make that determination, and you would only overturn if it's clearly an abuse of discretion. And as I've tried to make my point here and made in the brief, there was no abuse of discretion. The trial judge acted appropriately and made a reasonable, rational decision that I think we could all agree with. Or even if we disagree, I think, if rational minds could disagree, it's still not an abuse of discretion.
Since I mentioned mercy, can I take you to the claim of prosecutorial misconduct on closing, in which the prosecutor said that Mr. Kleypas didn't deserve mercy? And I know we have some case law that says, well, you can direct the jury to look at the facts and circumstances, but that's counterintuitive to me. If mercy is simply an act of grace, then it's something that's not deserved, not earned. It's not less culpable. It's simply an act of grace, and so you don't look at these facts and circumstances to determine if the defendant has earned it. Where is that wrong?
Give me just a moment to find my notes on that. What I believe the prosecutor said wasn't that, he said don't grant mercy if it's not appropriate, something along those lines. So, he gave the jury, he said if it's not appropriate. So he still left it to the jury to determine whether or not it was appropriate. So I don't think that he misspoke or made a misstatement of law or anything there. I think that was an appropriate argument for the jury's consideration, so I don't think it was misconduct.
The sentence that was it slowed me down a little bit, counsel, was you should simply you should not simply just abolish justice and substitute mercy if it is not appropriate. You're right, he used the word appropriate, but it's actually the wording right before that that slowed me down. It was, you should not simply just abolish justice and substitute mercy, because that makes it sound as though justice and mercy are inevitably inconsistent. And do you think that was an appropriate or a comment that we should excuse, or do you think that was error?
I think that was within the wide latitude allowed. I would say that it is an odd way to say it. I abolish justice and substitute mercy. I think what he was basically saying was, don't just substitute mercy here. What he's arguing is that justice requires the death penalty in this case. That's the state's position. That was his argument. And don't just substitute mercy for that if it's not appropriate. But then he went on to argue a few sentences later that mercy should be given out in appropriate circumstances. And then he went on to argue why he thought mercy was not appropriate. So
assume with me for a moment that we think that particular line was error.
okay.
Does that takes us to the analysis of harmlessness? You want to address that?
Well, I think that you could say, okay, he stepped outside the wide latitude, but then we have to look at whether it was a gross and flagrant error and whether it was motivated by ill will. And I think you can't find that it was a gross and flagrant error when, in the first Kleypas decision, the court said it's clearly proper for a prosecutor to argue against the granting of mercy, and he thought that's what he was doing. Now, he may have said it inartfully, but I don't think he was, he wasn't going way off the reservation there.
I think he actually said a couple times, yeah, you should think about it, didn't he? I think he actually said also a couple times, yeah, you should think about mercy. You should consider it. So,
Yes.
I mean, it wasn't as though he was telling them not to consider it at all.
Right, and I think that also goes to the ill will part, that he was arguing, his argument was, here's why mercy is not appropriate. He may not have said it the best way in that one line at the closing argument, but I think when you look at it as a whole, it wasn't gross and flagrant, wasn't motivated by ill will, and under the totality of the circumstances, I don't think that one little sentence was what tipped the balance in favor of the death penalty here. I mean, there was certainly overwhelming evidence, and again, this was the second jury to consider all that evidence to unanimously agree that the death penalty was appropriate.
But it does make a difference whether it was error or harmless error when we get to the cumulative error.
Sure. I mean, yes, yeah, it would. I'm not going to concede that it was error. I think that it was within the wide latitude, but following Justice Breyer's question, that assuming that it was error, what's my next argument? And I don't think it was a gross and flagrant error motivated by ill will, and I don't think that it possibly could have, tipped the scales.
You have a lot of time left, and I don't want to force you to go in the order that I want to go in, but there is a set of questions I want to make sure we cover. Do you mind if we go to a different issue?
Your Honor, I'm here to answer whatever questions you have in whatever order you want to ask them.
Okay. I want to talk about the categorical claim based on mental illness, and I want you to, for the moment, put aside whether Mr. Kleypas would ever qualify for that kind of categorical claim. So in other words, let's put aside the factual questions about whether he had a severe mental illness that fits some definition and just talk about the concept. And I'd like you to talk to me about why an actively psychotic individual would not be in the same position in terms of culpability for consideration for death penalty, would not be in the same position as a person with a developmental disability or a child. Why not? Why is there not the same kind of lesser culpability concern about an actively psychotic individual? So I want you to assume you've got somebody you can really prove was suffering from a psychotic episode. And that person may be competent to stand trial later because they're medicated and they can understand what's going on. So if that was where you're going to go, I was just going to tell you that's how I would answer you. So we'll skip that step and let's talk about somebody we have really solid proof was actively psychotic at the time he committed the crime?
Well, I think that such a person is already covered by the existing category that was established by the United States Supreme Court in Ford v. Wainwright, which is essentially you can't execute the insane. And they reiterated in Panetti v. Quarterman that the Eighth Amendment prohibits execution of those who are unaware of the punishment they are about to suffer and why they're about to suffer due to severe mental illness.
What was the year on that case, counsel?
Panetti was 2007.
Okay.
Ford v. Wainwright was 86.
Yeah.
But essentially, they said those, if you're so severely mentally ill, that you're unaware of the punishment you're about to suffer or why you're about to suffer it, then you can't be executed. But beyond that, execution is appropriate. Even a person who is a sociopath or psychopath is not mentally the same as the rest of us, but that doesn't reduce their culpability. They know what they did, and they know why it was wrong.
If they're not in an active psychotic episode. I mean, there's a line there, and and insane, really is not a word that is still applied, I don't think, for most individuals who suffer from mental illness, because obviously our knowledge of how to treat mental illness has advanced light years since even the late 80s. That's the part about that issue that's troubling to me. Is just I think that person shares the lesser culpability than a juvenile, like a juvenile, or shares it with a juvenile or a person who's developmentally disabled. If at the time the crime's committed, they're in that position.
Well, first I have to say, I'm not well versed in psychology or psychiatry. I don't know what it means to be in an active psychotic state, and advice being just psychotic in general, and that's why
psychosis is typically more acute. But anyway, go ahead.
I have a hard time getting my arms around this whole issue about what is the category of severe mental illness. What does that mean? It seems so squishy and ambiguous that it is a category that can't be defined, which means it can't be a category. I think that's the point we made in our brief. Again, I think that the U.S. Supreme Court has already defined the category for us as far as it can go, and that's what we should rely on. There's no precedent for this court to define a new category, and I don't think that the defendant has done a good job of defining what that category should be. I don't understand the parameters of what his category of those suffering from severe mental illness is. As I understand it, there's lots of severe mental illnesses out there. To point out in our brief that somebody could be suffering from a severe case of anorexia, or a severe case of depression, or a severe case of OCD. I don't know all the different mental illnesses that are out there that could be severe, but not all of them would reduce culpability.
Surely.
And so at best, I think you could make a case-by-case argument, and he didn't make that here. And the argument that he's raising for the court is a categorical challenge without a definable category and without actually proving that he would even fit into the category. I would point out that he did raise mental illness as a mitigating circumstance for the jury to consider. So it's not like the jury was prevented from hearing about this. They considered it, and they found that he was still culpable. And I think that's all that is required.
I think we ended up establishing that the other side is arguing for some sort of, as a matter of law category, that would be any finding to support it would be done by the judge prior to the proceeding beginning, rather than this case by case by the jury, which obviously he was entitled and did do. So anyway, okay, I just wanted your views on that. Thank you.
So, given what you refer to as the squishiness of the category, is that your position that because we can't define the category, we shouldn't remand? I assume, are there other reasons that we should reject the defense's suggestion that we need to remand this for a factual finding?
Well, I think the only reason you would remand is if you do find the category that you can clearly define, and then remand to see if the defendant fits the category. But I don't think you can define the category. Certainly, based on the defendant's arguments, I couldn't grasp the category. Now, I'm not the smartest guy in the world, but I just don't think that the category is definable. Severe mental illness is too ambiguous and too vague to be a category that would prevent the imposition of the death penalty. Again,
And if we disagree with you, then is remand appropriate?
Yes, I mean, because I don't think there's any way you can look at the cold record and say, oh, yes, he fits this category of severe mental illness. I mean, I think we need to have some kind of a finding by the court, and I think that in such a remand, both the state, the defense obviously is going to have their experts evaluate, but I think the state absolutely would be entitled to have its own experts examine the defendant so that we can rebut whatever argument they're trying to make. Does that answer the question? Mm-hmm. If there are no further questions on that issue,
I do have one. To the extent we're supposed to look for like categorical challenges for national consensus, what all do we look to? Your opposing counsel suggested that we should look beyond just those states that use the death penalty.
well, I think
do you have a
that
response to that?
I think that would inappropriately skew the analysis. I mean, there are some states that, for as matters of policy, their electorate, their legislatures have decided that they don't want to have the death penalty in their state, and it could be for a wide variety of reasons, completely unrelated to this particular issue. I think you would have to look at those states where the death penalty is imposed, because what we're talking about is where the death penalty is imposed, what are the parameters, what are the limits of that sentence. So I think you would look only to you should really look only to those states that have the death penalty. And of course, if you do that, there's no consensus at all. In fact, the consensus is, I think, 100% in the state's favor here.
If we don't accept that argument and we expand sort of the scope of what we look to include all the states, what's your response to your opposing counsel's suggestion that we should actually expand the scope even further and look to, I think the argument was the international community or the whole world or other legal bodies that have opined on this matter?
Well, I think you're not going to get you're comparing apples to elephants at that point. You're not going to get a consensus on the parameters of the death penalty as imposed in the United States under our Constitution and what we consider to be due process. You can look all around the world. I mean, there are some countries in the world that have the death penalty for a lot of things that we don't impose a death penalty for, and they do it in a particularly brutal manner. There are other countries in the world that don't have the death penalty, but the fact that they don't have the death penalty doesn't say anything about what they would consider the parameters would be if they did have the death penalty. So you really are, like I said, comparing apples to elephants. It's just not even the same category. And of course, we all know that while international law is out there, it's something we can all look at, but the supreme law of the land in the United States is the United States Constitution. So first and foremost, you have to look at United States Supreme Court precedent and what they say the Constitution says, and I think that really should end it.
So we can't go to the Kansas Constitution for Kansas citizens?
Oh well, certainly I was off on a national consensus
Right.
argument there, but certainly this court is the final expositor of state law, and so you can make your determination under state law. But I would say that there is no precedent for what the defendant is asking for here under state law. You would be having to weave something out of whole cloth. Briefly, I'll move on to the other issues that my opposing counsel covered. I don't know that I need to say a whole lot about the weighing instruction. The weighing instruction complied with the statute and with the United States Supreme Court ruling in Marsh. I don't see how that could be error. And if there aren't any questions, I'll move on.
Yeah, there is a question. In Kleypas 1, the Kansas Supreme Court, none of whom are here today, by the way, decided that the death penalty statute would be construed in a certain manner. Now, that was based on their determination that if you construed it a different way, it would be unconstitutional, and that premise turned out to be wrong. But it determined that the construction of the statute was this, and returned it to the district court with a mandate to apply that interpretation of the statute. Granted, then in Marsh, the underlying premise for the interpretation was determined to be incorrect. But why wasn't it incumbent upon the state to go back to the Supreme Court in this case and get a correction or a reconsideration of that ruling? And what authority does the district court have to change the ruling of the Supreme Court, even if the Supreme Court's ruling was based on an incorrect understanding of the law? Is that all clear to what I'm asking?
Well, we'll see if I answer it appropriately, and you can tell me. I think I have two answers to that. First as to why the state didn't seek some kind of clarification from the Supreme Court. I don't know of any procedure that would have allowed that, because we were well beyond the time for reconsideration. Or
You couldn't file a mandamus action in original action in the Supreme Court?
Justice Johnson, I tell you, I don't know. It would be a novel thing. I've never done that before. I don't know if that's been done for
Okay,
this
but
kind of thing.
granted, the procedure would be unusual at best. I grant.
Yes. The second part of the answer is that I think it's no different than when a case is proceeding and a new appellate decision comes down from any court that is on point and relevant to what the district court is handling. That controlling precedent will control the issue. And we had controlling precedent that essentially overruled the Kleypas decision that came down to the Marsh case.
It didn't overrule the Kleypas decision. It overruled the rationale that was used to render an interpretation, but it didn't overrule the Kansas Supreme Court's interpretation of a Kansas statute.
It didn't overrule it directly because it
Right.
wasn't before the court, but otherwise, I mean, it overruled the rationale behind it. It ruled on the issue.
And I'll grant you, the court would have been hard pressed to stay with its original ruling after Marsh, but the Marsh decision by the U.S. Supreme Court did not overrule the statutory interpretation of the Kleypas Court.
And I guess ultimately, I gotta wonder is that then, I mean, we acknowledge that the ruling in the original Kleypas was wrong, and so if the state had sought some kind of reconsideration, the court would have had to have complied with the United States Supreme Court ruling. So I'm not sure how the district court complying with the United States Supreme Court ruling is any kind of error.
It would have had to comply with the ruling with respect to the federal Constitution issue. It would not have had to comply with any U.S. Supreme Court ruling with regard to how it would interpret the capital statute. One would presume that it would take the plain language, but that doesn't always happen.
Well, I'm not entirely following you. I just don't think that, I mean, there's no way around it. I mean, the statute as written is constitutional. The instruction given complied with the statute. It complied with the Marsh ruling. I think this is really, we're really getting into a kind of a technical corner that makes no difference. In the end, what the district court instructed on was correct. It was the correct law. It's the correct statutory law. It's the correct constitutional law as interpreted by the United States Supreme Court. So I don't think it's error. And
Twice.
I'm sorry, yes, twice.
Can I ask a different question? Slightly less technical? Was that it? Did you want to say something else?
No, that's fine.
The mistrial issue having to do with the reference to the defendant testifying. You remember that issue? It was during the coroner's testimony, and the prosecutor was asking questions, and first he said something about the defendant making a statement, and then the witness answered, and then he made a reference to when the defendant testified. It was kind of an introductory phrase to the question, and there was an objection.
Yes.
I just wanted to ask about that. My understanding is the state's conceding that that was a fundamental error, and I was going to ask why. Because
Did
To
we?
me, in a mistrial, when there's a mistrial issue, fundamental error connotes something more than an ordinary trial error.
Well,
Do I misunderstand the law on that?
I don't believe that we conceded it was a fundamental error.
Okay, all right.
I certainly don't want to, I'm standing
Maybe
here
I
right now, I
misread.
don't concede that. If
Well,
that's,
could I get a clarification? When I read over that, it seemed like it was just a misstatement and
yes.
quickly corrected. Is that your position? I mean, was it more than that? I mean, was this kind of an intentional?
no, because
When the defendant testified, it almost appeared to me that it was just something. Oh, I said it wrong.
yes, he'd been asking questions about the defendant's statements to police, and then somewhere he said, when the defendant said this, and he said when the defendant testified, and I think he just said the wrong word. He just got it
That's what it appeared.
crossed in his head.
Okay, and that's your basic position on it. It was a misstatement that was cured, objection, cured, disregard testimony.
Absolutely.
In fact, I think Mr. Disney said it. I didn't mean to say it that way.
Right, and because I don't think the defendant ever did testify in
Right.
any proceeding. So, I mean, it clearly was just a wrong, just a mistake. I mean, you just got tongue-tied. And I'm trying to find it in my notes here. If there's, I don't believe that we would have conceded that that is a
Okay.
fundamental error.
If you don't,
That's
if you
what I
didn't
was-
concede it, then you don't need to tell me why you did, so.
I'm sorry.
If you didn't concede it, you don't need to tell me why you
Okay.
did. That was my question, thank you.
Are there any other specific issues that the court would like me to address? I would say that I know that I think that we've covered everything that opposing counsel spoke about, other than the mercy instruction, which I think the court has a good handle on. I mean, the mercy instruction is given what is required by PIC and what this court has approved in the past, and as the court.
Do you agree that if the defendant had not included mercy in the list of mitigating factors, that the prosecutor could have argued to the jury that defendant's not even asking for your mercy? That as a mitigating factor, if we label it a mitigating factor, which is certainly something to hang that hat on, then the defendant has to claim that mitigating factor?
I hesitate to go out on that hypothetical limb and say what the prosecutor could or couldn't do. I mean,
Well, the point is, if we call it a mitigating factor and the defendant is charged with the responsibility of verbalizing or setting forth the mitigating factors that the defendant is claiming, I don't understand why you would remove mercy from the list of claimed mitigators. You understand what I'm asking you? That's what happened here. Here's the list of the mitigating circumstances that I'm claiming, and included in there was mercy. And the
judge struck it.
just struck that, and if it's a mitigating circumstance that and the defendant has to claim the mitigating circumstances, I don't understand why it was stricken.
well, he struck it because it was already included in another instruction, because I believe
It was included that it can
Same
be.
instruction.
That it can be considered, but that's different than the defendant claiming it. If we're going to label it, I don't agree with the label that it's a mitigating factor, but if that's the label, then why don't we treat it the same way as any other?
Well, honestly, I think as a practical matter, it was treated the same way. It was included in the jury instructions. You have to look at the jury instructions as a whole. It certainly was discussed at length by both the defense and prosecution. I mean, I would point out that, as this court has recognized, no specific type of mercy instruction is required under state or federal law. That came out of Clipus. So if nothing is required, then I don't think it could be error. I would personally, if before a trial, I would never advise a prosecutor to argue that mercy is not appropriate, because the case law indicates that it is. So that's why I don't want to go out on that hypothetical limb about, well, what if the defendant didn't ask for it, what could the prosecutor argue? Well, I don't want to go there, because I think that's just going to get me into a pitfall that I don't want to fall into. The fact of the matter is, in this case, the jury was instructed on mercy. The parties argued it, and the jury considered it. And
council mention had been made by opposing counsel about the Fourth Amendment issue that she spent quite a bit of time on, and my notes indicate that you kind of dismissed that argument by saying it's not something we should be considering. Do you have anything further for us to consider?
Well, I mean, I could go at length about why. I mean, it is final. I mean, this court affirmed the convictions. It rejected the defendant's argument in the first appeal, and I think the biggest indicator that it's final is just got to ask yourself: following this court's decision in 2001, could the defendant have petitioned for certiorari to the United States Supreme Court and raised that argument? The answer is yes, because it was a final decision. He didn't raise the argument in his petition for cert, and so it is now final, and it is no longer an open question for this court to consider. What happened afterward, the Groh case doesn't apply, doesn't reopen. This court has no basis to reopen its prior decision in the direct appeal. The only thing at issue in this appeal is the resentencing. That's my fundamental base argument. And if you want to dig into the Groh case, the Groh case didn't really decide what opposing counsel says it did. It basically noted that it talked about courts requiring words of incorporation or the accompanying affidavit or both, but it noted that neither was present in that case, so it wasn't going to discuss the matter any further. And that's all it said. It didn't say that both were required. And then we subsequently have a Fourth Circuit case, the U.S. v. Hurwitz, which essentially rejected the very argument the defendant is making, that both words of incorporation and the accompanying affidavit are required. The Fourth Circuit said that that's not what Groh held, just as I just stated. When you look at what happened here, I think the court in the first appeal got it right. The officers recognized the defect in the warrant, so they got the affidavit that listed everything that was to be searched for and seized, and they proceeded from there. They had good faith basis for doing that. They had case law, state case law that said that was appropriate. But I think the biggest indicator that they acted in good faith was this court, reviewing the issue, approved their actions. I mean, how could they be, acting outside the scope of good faith when the 7 justices of this court said what they did was okay? So if you get all the way through that, I still think there's no error. And ultimately, even if you decided it was error, I mean, what harm did it have in this particular proceeding? I mean, it wasn't an issue for that. I mean, all the evidence was suppressed in the sentencing phase. If you were to go back and reopen the trial for this issue, I think when you look at the totality of the evidence, it was a harmless error. I mean, we had the defendant's own confession, we had his DNA in the crime scene and so on. The error in the search was harmless.
I'd like to return to your statement that the test we should apply for the finality is whether the defendant can petition for cert on the issue. Are we looking to state law when you make that statement as to what we determine is a final judgment in our court, or are you looking to something that the U.S. Supreme Court is a standard they have set for what they determine to be a final judgment?
Well, that's fair. I mean, that is really how the United States Supreme Court would treat it as a final judgment. I think this court, I don't know that this court deviates from that. I've never seen anything deviating from that. If I'm wrong on that, please let me know. But I think as far as state law goes, the same way, that once the conviction is affirmed, it's final. Once the avenues of direct appeal have been finished, have been exhausted, which in the case of the guilt phase had been done when this court affirmed and the U.S. Supreme Court denied cert. At that point, direct appeal on the convictions was final.
I think both this court and the U.S. Supreme Court say a criminal judgment is a conviction and a sentence. And the Supreme Court has recognized at least 4 exceptions. Is that where you are?
Yeah,
is it
I
an
think you have to.
exception area?
Yeah,
or?
You have to take that statement in context. Yes, in conviction and sentences is final because, for example, if someone's going to go seek federal habeas, well, you can't go seek federal habeas relief if your conviction in state court is final, but you're still waiting on a sentence, so the sentence has been remanded, because you have to be under a sentence of the state court, and for rules of comity and so forth, the federal courts don't want to get into a case if there's still state proceedings going on. All right, if they want to, in federal habeas, they want all of the issues exhausted in state court before it gets to federal habeas. But in the case of a direct appeal going to the U.S. Supreme Court on a petition for certiorari, they make a distinction there. And as I laid this out in my brief, that there are times when other proceedings below are going to continue. I mean, the Marsh case is a perfect example where, again, we had a remand for resentencing. There were going to be proceedings below. In fact, his convictions had been reversed as well, but we took it. We took the sentencing, the constitutional decision to the U.S. Supreme Court. They said that was a final decision, so they would consider that. So yeah, there are exceptions, and in this case, the decision on the search and the guilt phase was final at that point in time, because they could seek a petition for cert. The U.S. Supreme Court would have considered it a final decision and would have looked at it. At this point in time, they've missed. I think if they were to file a cert petition, they would be way out of time and wouldn't get any consideration. The fact that there was a resentencing had no bearing on the constitutional question at issue. So therefore, it doesn't render it not final. Does that make sense?
Yes, I mean, I understand what you're saying, at least.
Did the state petition for cert on the Kleypas one's interpretation of the?
The state did not petition for cert.
Could you have?
Could have, yes.
Yeah, under
Although
what I hear you describing, and like what you did in Marsh, you could have petitioned for cert at that particular time. And what does that mean that you didn't seek review of that?
Well, I know what it meant as a practical matter is that everyone looking at the case said, well, we can live with that decision, let's just move forward. That's the practical reason. Are there any further questions from the court?
No further presentation?
If there are no further questions, Your Honor, then I would simply submit the rest of the issues on our brief and ask that the court affirm the lower court decision.
Thank you, counsel. You reserve 15 minutes for rebuttal.
May it please the court, just to pick up where opposing counsel left off on this final judgment rule thing, I don't even know how we would do a lot of the things that he's suggesting, given the time limits for filing habeas petitions. If we have to file a habeas petition, if, in this case, for example, if the convictions were final and we were supposed to start habeas proceedings several years ago now, I guess, but we don't have a death sentence or not, I don't even know how we do that, and the piecemeal litigation that would result kind of makes me break out into a cold sweat a little bit. I don't think we want any part of that. And as far as filing cert petitions goes, the way we've kind of looked at it in this case and in other cases is sort of a may we file cert now, must we file cert now, can we file cert now kind of questions. And what you do, of course, depends on the case. And I think Brady actually is really illustrative here, because in that case, the defendant filed a cert petition basically because he didn't want to go back and have the other proceedings. And that's kind of what happened in this case, actually, because Mr. Kleypas did indeed file a cert petition to keep from being resentenced. So I think there's permissive cert petitions and mandatory cert petitions. And basically overall, as Justice Lukert has said, in a criminal case, final judgment is sentence. And I just don't think we want to get into a world where we're making a lot of exceptions to that rule. It seems like a bad place to go. Again, briefly, as to the mistrial issue, talking about highlighting this further to the jury, there were jurors sobbing. And that's on the record, and that was not disputed by the state at the time. There were jurors sobbing over what happened here. So any suggestion that this cut in favor of Mr. Kleypas, or that they could just forget it after it was a 15-minute recess, half an hour recess, I believe. Again, I think that's silly. And as Justice Johnson,
I mean, is it silly to say that it just couldn't have cut in favor of Mr. Kleypas, of your client? I mean, there could be some sympathy evoked on the fact that he got attacked. I mean, you just don't know. I mean, I would agree, perhaps that's a stretch, but it's not, or is it a stretch? Why is it? I just don't think you can assume that this all worked against your client.
they felt so sorry for him that they gave him a death sentence.
I'm not saying that, but I think it could equate to the position he's in, and that's just the circumstance that he got attacked. I think it could.
I don't think that the state has proved that beyond a reasonable doubt.
No, I understand.
As they're required to for the harmlessness.
You're assuming that this results in prejudice to your client automatically.
I think that the state cannot
It's piling on.
declare this error harmless. Cannot declare this error harmless beyond a reasonable doubt. I think that's where the harmlessness standard goes. And as Justice Johnson was saying, we have to get one juror here, and that's how the Eighth Amendment piece affects the Ward test in this case. Is because it's that much higher of a burden where we only have to get one juror. And then the big thing I wanted to stand up and come back to is this idea of the categorical challenge under Section 9, now that I've kind of had a minute to think about it. And I think 216619 is the statute I was trying to pull up that says that this court can consider sentence in capital cases. So I guess what I think a categorical challenge would look like under Section 9, it's hard to say because this court hasn't routinely obviously construed the Kansas Constitution to mean different things from the federal Constitution. So to the extent that we are, we have to kind of, I don't want to say make up our own tests because that's taking it too far, but construct a framework to look at it in. And I think that the way that SCOTUS does it actually does make some sense in looking at the evolving standards of decency and then bottom line making an independent evaluation of, in this case, Section 9 and what it requires. And as far as the evolving standards of decency goes, I think that...
Let me have you back up for a second, counsel. I think you're talking about a Freeman-like challenge under Section 9, not categorical. Because categorical is you have a category, like a severely mentally ill person. You're talking about what would be the analog to Freeman under Section 9 for a capital case rather than a term of years case.
I don't think that's what I'm talking about, Justice Breyer, but let me try again.
Because my understanding is when you talk about evolving standards of decency and making the court's own evaluation, that's not the categorical challenge for the court, for the U.S. Supreme Court. That's the individualized proportionality challenge.
By evolving standards of decency, I mean the analysis that they do when they look at what other states are doing, what other countries in the world are doing. And another thing that they look at actually is the actual number of executions, which in Kansas we've had none so far. So we're not executing anyone who's mentally ill yet. And I think fundamentally, and I think probably this is like Justice Scalia's nightmare, right? That once you start excluding people for age, for developmental disability, then I think, as you said, Justice Breyer, it becomes hard to come up with a principled reason to then not exclude people with severe mental illnesses too. And that, I think, kind of plays into that sort of evolving standards of decency analysis, and particularly in Kansas, where we're not really looking to other states so much because we're interpreting our own constitution, right? And then I think we can look at the independent evaluation part of it, which they look at retribution, deterrence. Does the penalty further those objectives? And I think for the reasons that apply in the Eighth Amendment analysis, executing mentally ill people just it doesn't further those objectives at all, because obviously people with mental illness are less able to control their actions to begin with. Less culpable generally, and also I think in Atkins and I think they talk about it in Graham as to juveniles. They talk about how people with developmental disabilities and people who are young are also less able to kind of fully take advantage of due process because they can't work with their counsel appropriately. They don't make good witnesses. They don't remember things accurately. In this case, my client was basically basically claiming he had sort of a dissociative episode. And their demeanor in court, their general demeanor, may make them look like they're not remorseful. So I think you can look at all of those things under the Section 9, as a Section 9 categorical challenge in evaluating whether our Kansas Constitution allows the execution of the mentally ill. And I think it's similar. Doesn't necessarily have to be exactly the same, but I mean, I think that as SCOTUS has a duty to independently evaluate the Eighth Amendment, so this court has a duty to independently evaluate Section 9, and that provides a decent framework for doing so, I think, at least.
What in Section 9 could we look to make the kind of finding you're requesting, which, as I understand it, is that Section 9 may actually provide greater protections to defendants facing a capital conviction than the Eighth Amendment?
Well, I think, again, one thing we can look at is, as we're talking about evolving standards of decency, and that has a component in the language of the Eighth Amendment, SCOTUS has found at least, we can look at, again, executions that have taken place in Kansas, and so far there are none. Generally as a people, we don't like to kill people, apparently, or at least we're taking a long time getting started about it. I think we can look to that to evaluate it independently. What we think the standard of decency is in Kansas, particularly.
There is a textual difference.
Yes, and that's true too. The Kansas Constitution does say cruel or unusual as opposed to the federal and unusual, which I think is a point we made in our brief.
And the history indicates that the fight was over whether to use or nor, not whether to use and.
And I think, we also took a long time, if you look at abolition in the 70s, and we also took a long time to get our death penalty back, which I think shows a certain reluctance there too, just speaking of the history. If the court has any questions, I would be happy to take them.
Yes, I'd meant to ask you about your issue 8 on the Tom Williams testimony.
Mm-hmm.
In your written argument, you referred often to the court not having notice, or that when they gave notice, the court didn't know what it was and didn't have an opportunity to rule on the relevance of some of the evidence, especially some of that moved from your argument that it moved from the genetic markers into the DNA.
Mm-hmm.
So I just wanted to clarify, are you suggesting that there's a statutory or some other duty that requires notice to the court and advanced rulings on relevancy in the penalty phase?
I don't believe so. Basically, our argument on that DNA issue, and the problem is really one more of omission than of actual affirmative misleading testimony. The problem is when Lisa Villalobos testified at the original trial, she explained extensively what she meant by genetic markers, which was essentially blood typing. This person was type A, this person was type O, and so forth. I'm oversimplifying it, but I think you get the point. When Tom Williams testified at the second penalty phase, he only mentioned DNA. He didn't explain all of that back history about blood typing, so the second jury didn't have that additional background information. So when he was saying genetic markers, the only thing they had to reference back to was DNA. And as we know, jurors tend to take DNA evidence as gospel truth, regardless of what it shows or what it doesn't. And in a capital proceeding where residual doubt is always, up for grabs, that's a problem. That's why we're arguing that that's harmful there.
Can clarify for me, wasn't there some discussion between counsel regarding the testimony of Agent Williams and the scope of that testimony? And it was never put on the record, but absent an objection to it, what are we to assume from that discussion? I mean, Agent Williams did go into the testimony of the other agent in the serological evidence, but how do we know that that wasn't agreed to as a part of their agreement? And if there's no notice requirement, where are we at?
Well, I mean, we can only rely on what's in the record on appeal. If we can't rely on the record, then I don't know what
But there
we
was
would
no
do.
objection to it, and we know that there was some discussion regarding his testimony.
The discussion on the record was that the state was going to be substituting Tom Williams to testify about what Lisa Villalobos found regarding the DNA on the victim's breast, leg, and ankles. That is what we agreed to on the record. And they went far beyond that. So, and would I prefer that there had been an objection there? Of course I would, but I think that this court can still get to it under the capital preservation statute.
Okay, I get to it, but how do we deal with the more relaxed evidentiary standard that's in the sentencing aspect of this when it comes to this also? Given that there was some discussion about it, there's a relaxed standard. What's the problem now?
Well, I think that, the defendant waived certain objections, but I don't think that they waived every possible objection, based on, again, what was said in the record, which is what we have to rely on. So that's, I guess, how I would answer that.
Okay.
Any further questions? Any further presentation?
We would ask that Mr. Kleypas's convictions and sentence be reversed, in this case be remanded as this court deems appropriate. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. That